Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the continuation in a Lawcast series detailing testing the waters when conducting an offering using Form S-1. The waiting or pre-effective period is that time frame between the filing date of a registration statement and the effective date. As with all periods in the offering process, communications with potential investors are strictly limited and regulated during this period. Also, as with other offering periods, many exemptions and safe harbors exist to allow for communications during this pre-effective waiting period. A free writing prospectus would include any written communication that could constitute an offer to sell or a solicitation of an offer to buy registered securities and is used after the filing of a registration statement and before its effectiveness. A free writing prospectus is a supplemental writing that is not part of the filed registration statement. If the writing is simply a repetition of information contained in the filed registration statement, it may be used without regard to the separate free writing prospectus rule. For purposes of the rules related to free writing prospectuses, all communications that can be reduced to writing are considered a written communication. Accordingly, radio and TV interviews, other than those published or given to unaffiliated and uncompensated media outlets, would be considered a free writing prospectus and subject to the SEC use and filing rules. All free writing prospectuses must contain a specific notice legend as set forth in Rule 433 of the Securities Act. A free writing prospectus must be filed with the SEC using Form 8K no later than the date of first use. An after-hours filing will satisfy this requirement as long as it is the same calendar day. Moreover, all free writing prospectuses must be filed with the SEC, whether distributed by the registrant or another offering participant, and whether such distribution was intentional or unintentional. A free writing prospectus may not be used by any issuer that is ineligible for such use. The following entities are ineligible to use a free writing prospectus: companies that are or were in the past 3 years a blank check company, companies that are or were in the past 3 years a shell company, penny stock issuers, companies that conducted a penny stock offering within the past 3 years, business development companies, companies that are delinquent in their Exchange Act reporting requirements, limited partnerships that are engaged in an offering that is not a firm commitment offering, and companies that have filed or have been forced into bankruptcy in the past 3 years. Microcap companies will rarely be eligible to use a free writing prospectus, and when dealing with smaller issuers, it is always important to conduct a qualification check prior to using a free writing prospectus. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance and producer of Lawcast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.